Good afternoon, everybody. Warm welcome to episode number 5 of Stewarts Soundbites. I don't know where the time is going. We seem to be locked in this kind of warped time at the moment where everything's going really fast, even with the monotony of being constrained at home. So I hope everyone's keeping sane. So today I'm really lucky because I'm being joined by Jemma who is a director of EMG Solicitors, and she heads up the Court of Protection team. And we thought today it would be interesting to talk a little bit about health and welfare decisions in relation to incapacitated clients. We hear loads about finances and property and affairs and those deputies, and I thought it would be a bit interesting to touch on the health and welfare issues, which are kind of less common. So Jemma, we're doing this in sort of a Q&A format, so I'm just going to start with the first question. So working in the field that we do, most of us have a reasonable grasp as to the role of a property and affairs deputy. But as I said, today we're talking about health and welfare, which is kind of a much less common animal, particularly health and welfare deputy.
Yeah.
First of all, how do we know when a person might need a health and welfare deputy? And can you explain a little bit about what the main duties of a health and welfare deputy are, and who's normally appointed to take on that role?
Yeah, no, absolutely. So I should start by saying, obviously, I'm a property and affairs deputy by trade. I started life as a health and welfare practitioner and kind of moved into the P&A field. So my colleague Eilish is definitely my go-to person now for all health and welfare issues. But certainly from both of our experience, the court the starting point is not appoint a health and welfare deputy, which I think is the opinion that most people have at the moment. The starting point is what's in P's best interest, and that's really the kind of buzzword in all court of protection issues. Where you look at where someone needs a deputy, obviously they need to lack capacity. The Court of Protection don't have jurisdiction unless that's the case, and they specifically have to lack capacity to make health and welfare decisions. So, having a capacity assessment, for example, for litigation, for P&A matters, isn't transferable. It's got to be an assessment in its own right on those issues as they stand alone. And all capacity assessments are time and issue specific. So you might need to see yourself getting renewed assessments of capacity, particularly for someone that might have fluctuating presentation. But despite what I've said about the starting point not being not to appoint a health and welfare deputy, the courts, we find, tend to be quite reluctant. There was a case in 2019 called Lawson, Mottram and Hopton, and people can have a look. There are some good summaries out there, so you don't have to read the entire judgment. But it does boil down to whether it's in P's best interest to have a health and welfare deputy. And often we find it's where there are lots of kind of linked health and welfare decisions that need to be made, where there might be family conflict. So we've all been involved in those cases where things run really smoothly and everybody agrees, and that's brilliant because you can make lots of on the ground health and welfare best interest decisions. But where there is a point of dissent and it's going to kind of crop up frequently, then a deputy might be kind of the best place to start. But yes, it's still quite rare. I mean, I was looking at some stats for you, Emma, and in 2019 there were 13,000 appointments for a P&A deputy, and there are only 395 health and welfare appointments. I don't know what the split is. I couldn't find the information, but it's more commonly going to be a family member. But there are still some restrictions. Even where you appoint a deputy, there are still some things that you're not able to do. There are restrictions for both P&A and health and welfare ones. But yes, they certainly can't authorise a deprivation of liberty, and they can't prevent contact, for example, between P and a named person, amongst other things.
Okay, that's really interesting. And the case that you mentioned, Jemma, I can include a link to that in the closing slide to the recording if anyone is interested in it. No one wants to read the full judgment, so I'm sure we can find some good summaries as well.
One in there. Other barristers are available, but I've got one that I can pop across to you. We've used internally.
Perfect. So where I know that you've said that the appointment of a professional health and welfare deputy is fairly rare, but where one is appointed, are their powers pretty limited, or do they have a wide discretion? And how important or how important do the families, friends, carers' views become?
I mean, so yes, the court will absolutely have in their mind a limit to authority. I mean, it's important to say as well, when you're looking at the appointment of a health and welfare deputy, it's always about taking the least restrictive route. So you seem to think that, you know, having a health and welfare deputy will just resolve all of those issues about making those important decisions, and they'll be able to do everything. That's not the case. You still need to involve P wherever possible. You need to consult with everybody that's involved in P's, you know, care and kind of well-being as much as possible. So it's still kind of heavily consultation based. And even still, there are some things that health and welfare deputy can't make decisions about, like I said, in relation to deprivation of liberty and contact with P. They also can't make decisions about, you know, serious kind of treatment and withdrawal of treatment. You know, so I think anything outside of the deputy's powers would fall to kind of section 4 decision making. But yeah, consultation is really important, and you've got to consider their past wishes and feelings. So pre-injury, for example, if it's not a from birth situation, and also got to consider their current wishes and feelings. You know, and speak to everybody involved and see whether or not an on the grounds best interest decision can be made, because that's the preference. You know, sometimes even if there appears to be an initial dissent, you know, at one party isn't agreeable with a certain course of action with regards to residents or with regards to a certain type of medical treatment or procedure, the hope is that by having that kind of group best interest decision meeting, everyone can sit down and discuss it, you know, debate the pros and cons and come up with a mutually agreeable kind of way forwards. And that's what we find tends to happen in practice, which is probably why the numbers are really low for the appointment of a deputy, because the court would generally prefer that that route be taken first, you know, and that really they're only involved for those ad hoc, you know, single issue specific decisions, you know, that where a consensus can't be reached, or the matter is so serious that it can't be made at that level. And
I suppose when there are disputes, then it's, you know, there are different things to consider then when there are disputes in terms of, we'll come on to that in terms of next steps and going to the court of protection and what have you. But you've touched on this already, Jemma, but can you expand a wee bit on why the court seems so reluctant to appoint these deputies, and what's the alternative? You know, if families can't agree, and if there's a bit of a dispute, is there a process?
Yeah, I think the reluctance just stems from the fact that the court just feels it's not necessary for one to be appointed. I mean, sections 4 to 6 of the Mental Capacity Act allow for a lot of decisions to be made on the ground. You know, they give a really clear kind of guidance on how these best interest decisions can be made and what practitioners are expected to do. So it's definitely worth reading those if people haven't, and if they're involved in kind of health and welfare for an individual on a regular basis. And it also puts limits under section 6 on the decisions that can be made. But it does provide some restraint in certain circumstances, you know, for example, where it's necessary and proportionate for the risk of harm, you know, so they can be restrained if necessary. But yes, best interest decisions can be made on a frequent basis. It can be made by one person, but in consultation with lots of people. So in my practice, I find that I can sometimes, you know, be involved in a welfare best interest decision, even though I'm a finance deputy, because I form part of the team. And a lot of the time I'm making a decision based on the affordability of a regime. So it might be, you know, we're talking about where someone's going to live, and, you know, I'm involved because I'm possibly purchasing that, or I'm involved in the kind of funding of a care package that's going to be in place. So, you know, but I might not be the ultimate decision maker. That might be someone's appointed case manager, that could be a social worker, you know, that may be a head of family, so mum or dad or spouse, you know, so you still want to try and identify a decision maker, but it doesn't have to be somebody in a legitimate kind of court appointed capacity. But we are seeing more and more professional deputy kind of discussions taking place in the health and welfare arena. You know, it's not something that we saw a lot of. I mean, myself and Emma, we've got one health and welfare professional deputyship, and we're waiting for a decision to be made in relation to another application.
Wow.
But certainly from my talk with other deputies who tend to do P&A primarily, they don't have any. And it's quite rare to have even one. They're not something you see commonly, but we've certainly had, 2 or 3 instructions in the last 12 months about whether we would be prepared to act if it became necessary. And I think they're largely situations where the client has nobody, or they're from a really dysfunctional background and you cannot get that consensus. And there are going to be lots of these linked decisions if they've got specific, particularly if they've got really specific or complex healthcare needs, or if they've got a combination of psychiatric issues and they're in and out of inpatient units, and decisions need to be made frequently and urgently. Definitely seen a rise of those, and we've done more and more statements kind of incorporating the costs of a health and welfare deputy.
I mean, as with everything in our jobs, Jemma, there's never an easy answer. There's never kind of a black and white, here's a list of people that can make a decision. But I guess with these complex cases, and as you've referred to, the complex dynamics of some families just don't lend itself to that sort of black and white situation. So there's no easy answer.
It's very person-centric as well, that's the difference. It might be with certain areas of law, it's process-driven. Once you've done this, you need to do this, and yes, you might get some divergence because something comes out that you're not expecting, but then you go back to your process once you've dealt with that issue. But with this, it's person-centric. It's all around P. It's what's in their best interests, and what's in their best interests you can't necessarily replicate to another client's case. So it does. It's very, it's very unique, and it's got to be super bespoke to their own individual circumstances. And so, but we are seeing a progression in the courts for a move towards, appointing more health and welfare deputies where it's necessary and proportionate, and where others have been tried and tested and failed.
And I suppose from a practice point of view, Jemma, it's good for people that are involved in these cases, I suppose, to kind of clearly document discussions that have taken place, and kind of the things that have been taken into consideration in reaching a certain decision, and having that documentation from a professional point of view is always good, I guess.
No, it is, absolutely, because we certainly within our firm we have best interest decision making memos, so that whenever we do make a decision, and that's on a P&A basis, but we definitely say it's good practice in anything that you do, to document them well, so that if there is any question when someone's going back to say, why did you make that decision, you can just pull up your memo and say, these are the things that we considered. We took the MCA into consideration, we looked at least restrictive, we took P's wishes and feelings, we spoke to the family, and this is the decision that was made. And then when you've done that, it doesn't work, you've got your evidence for your application for why a deputy might be necessary.
Of course. And we've got about 2 minutes left, so we'll fly through the very last question. Is it possible or reasonable for someone to appoint a health and welfare LPA, lasting power of attorney, to kind of circumvent the need to go to the Court of Protection if these kind of issues arise later on down the line? Okay, so I suppose the issue is requisite capacity. So you can only appoint an LPA if you have capacity to do so. So you might have some clients, and again, it's issue specific. So someone who has clearly not got litigation and financial capacity in a substantial PI claim, for example, could still have capacity to appoint an attorney, and you can get a capacity assessment. If you've got that, you can do an LPA, absolutely, and that can appoint a health and welfare deputy, health and welfare attorney. And so yes, it's definitely possible, but it all depends on the requisite capacity. If capacity is not there, then no. Your only option is the COP, and it's applying for a deputy if that's appropriate in the circumstances. Sure. And no one's going to put that in place. No one's going to necessarily really think about putting that sort of thing in place. If we're dealing with someone that's been involved in an accident, you're not going to have thought to put that sort of thing in place beforehand. Because
typically you reach a certain age and you start thinking about the management of your affairs and making decisions, and we always associate it with kind of dementia-related capacity and the loss of. We tend to find that people who are of a certain age, no, they haven't thought about these things and haven't put them in place prior to a catastrophic injury.
Of course. Understandably so. That's what happens, isn't it? Yeah.
Yeah,
Well, listen, Jemma,
absolutely.
thank you ever so much. I always feel cheated at the end of these sessions because I feel like we haven't had enough time. That's the whole point, is that we give everyone kind of a soundbite in a 15-minute sort of whistle stop tour. So really appreciate you being with us, Jemma. It's so good of you, and I find that so interesting. I'm going to include your details, so you have to forgive me in advance if you have lots of queries.
No, it's
but
fine.
we'll include your details and Eilish's details as well, as you've mentioned.
If it would help, Emma, sorry, I know that we're struggling for time, but Eilish did do a presentation last year that kind of covered this. If people were interested and just wanted some slides that they could go through at their own leisure, I'm happy to share those as well.
Oh, perfect. Well, we'll include your details, Jemma, and people can always ask me or ask Jemma directly if they'd like access to those. Thank you. That's really good. So that's us for today. Everybody, next week we're back. We've got a session. We're going to do a sort of quick fire guide to welfare benefits for people after serious injury, and we're going to talk a little bit about the impact that COVID has had on that process, and some detail about appeals processes as well. So really interesting stuff. So hopefully I'll see you next week, and thank you very much, Jemma. Take care, everyone.
You're welcome. Thanks. Bye.
Bye.